Doesn't having a TOD on title also avoid probate? It depends. So you can put a TOD, transfer on death, on title to certain assets in some states, including real estate in some states. You can do a transfer on death deed. The intention here definitely is to avoid probate. You're listing a beneficiary essentially on whatever that asset is, right? You're making sure that someone is listed who gets it after your death, sometimes more than one person. It is a way to avoid probate as long as that beneficiary does outlive you. What we see sometimes, what can happen is if the beneficiary passes away, then the asset needs to go through probate. Or sometimes, like on title, you can name, say, two kids as an example. You name two kids as TOD recipients on the title of a home. Let's say you want those kids to inherit the house 50-50, 50% each. So they each get an undivided 50% share of the home. And you want it so that their share would pass down to their kids in the event that anything happens to them. Okay, fine. But then what happens is if something does happen to them, they pass away, then their 50% has to go through probate. So you're still looking at probate. Same with if you list a TOD or multiple TOD recipients on assets and the beneficiary passes away. We see this all the time. It's people say, I'm going to remember, or it's going to be easy to change, or if something happens, I'll just change it. But you don't always get around to it. Sometimes certain assets get forgotten about. So if you listed a TOD recipient on something and then that TOD recipient passes away before you, then the property is subject to probate again, whatever it is, or the asset. Whatever the asset is, it's going to be subject to probate again. Which is why trusts, forming some type of a trust, most commonly to avoid probate, it's going to be a revocable living trust. Excuse me, but if you form a trust, you can account for any eventuality. So if this person dies, then their share goes here. Or if both people die, or all my beneficiaries that I list here die, then this happens. You can basically list out in order, successive order, who gets what, and if that person isn't here, who gets their share. And this can go on and on and on until you get what you end up with as an ultimate beneficiary. Was like if everyone who I list predeceases me, then who does it go to? So you really don't run out of beneficiaries with a trust, and you don't have to keep on making changes if you have beneficiaries who pass away, which you would need to do with a TOD. Another thing you would need to do with a TOD is if you list a beneficiary who ends up needing to be on government benefits at some point in their life. Maybe they need to be on disability or they need Medicaid benefits. If your TOD, which is essentially a beneficiary, so the person who's going to transfer to on death, if they're receiving some type of benefit, and then they get an asset from you immediately that's not able to be held in a trust, a supplemental needs trust or a special needs trust, well then guess what? They just lost all their benefits. And most of the time, whatever they're going to be inheriting isn't going to be worth it in the long run for them to lose all their benefits. So there's a few different reasons, and there's more. It's like a minor can't inherit, for example. So if you do list it to your child, but your child passes away and the intent is for their kid to get it, but the kid is 12, guess what? Kids can't, inherit assets and property directly when they're under the age of 18. So there's several reasons why a trust is often preferred in this scenario, because if you are simply listing direct beneficiaries, you're only really covered if everything works out in the ideal scene, right? Whoever you list outlives you. Anyone you list on there outlives you. Nobody needs to be on benefits. There's no minors involved. So all those things could happen. It's possible, but depending on when you're putting these beneficiaries on, your age, how long you plan to have the asset. I mean, a lot of things can happen over time. And we see a lot of different things happen in different scenarios. which is why it's often better to have one document, a trust agreement, that lists out every eventuality. And then if those assets or your property are owned by your trust or come within your trust, then you're going to be able to account for any eventuality. And that's really the only way to 100% ensure that you're going to avoid probate. All right, I hope this helps. If you have any other questions about the difference between TOD, transfer on death, POD, payable on death, and trust, or any type of estate planning question or elder law question, contact our firm. The link is in my bio. We are in Clearwater, Florida.